では時間になりましたので始めたいと思います。皆さん、こんにちは。このセミナーは、米国特許セミナー、ExaminIrks です。いつも各週火曜日のランチタイムにお届けしています。講師は、特許弁護士であるブライアン・エプスタインさんです。今回は第4回目になります。前回までは USPTO の審査官とのインタビューがテーマになっていましたが、今回は応答書について解説いただきます。具体的には応答書において MPEP と判例を引用する際に注意すべき点について解説いただきます。それではブライアンさんにお話しいただきたいと思います。Okay, Brian さん。Session 1, Session 2 primarily focused on interviews. Even Session 3 still discussed interviews. Our attendees cannot attend interviews easily. How can we improve our written responses?
Sure. So an easy way to really improve the written responses is to improve the citations. And I am having problems switching slides here. What is going on? Okay, there we go. Sorry about that, everybody. All right. So I guess the easiest way to begin is by focusing on the MPEP citations. One thing that I've heard from examiners is that some practitioners quote extensively from the MPEP in their responses to office actions. And the MPEP, of course, includes the guidelines for the examining corps. And the significance of that is that, the examiners generally know what the MPEP says. They're required to know. They're taught that, the rules in the MPEP are how they should conduct examination of patent applications. And so, maybe your examiner has forgotten a particular section or doesn't know how to apply a particular portion to an office action or, your applicant's response. But generally speaking, the examiner can conduct their own research. It's very easy for them to open up the MPEP, there's digital copies these days, and find the relevant portion that is cited to them in an office action response. And so therefore, as representatives of our applicants, we should use the relevant portions of the MPEP, of course, but keep the quotations to a minimum. What is the minimum? Generally speaking, we're talking about 2 or 3 sentences. Certainly sometimes you can make your point in a single sentence, sometimes in very unusual circumstances or a particularly niche issue, we might cite 4 or 5, 6 sentences, whatever. But really, we're trying to quote the minimum necessary to make our point. And once we do that, we should include a citation to the MPEP so that the examiner can read the portion in context. So, just after you quote it, say MPEP section 2112, Roman numeral 4. Why is that important? The examiner is, like I said, they're familiar. They know where to look. They'll look it up and they can read it in context, which means they can read, the entire section. And that's important because if your examiner doesn't know the portion of the MPEP that you're relying on, let's say it's something to do with consideration of non-English references in an IDS. That's pretty fact specific. It's not something that examiners see all the time. They'll want to look up the whole portion. The other issue is that, especially when we get to things like election or restriction practice, there are parts of the MPEP that might be good for an applicant, and a portion of that same section that might be, bad for an applicant or better for the examiner. And examiners are aware of this, and they will want to read the whole section to see how the MPEP distributes, for example, the different responsibilities between the examiner and the applicant. Your examiners aren't just going to take your word for it. They want to see what the full rule really is to know if, they should listen to what the applicants say. So what's really important there is, explaining how the MPEP applies to the facts of the present application. You can't just quote the MPEP. You need to really sit down and explain to your examiner, this is why, this is the standard for inherency. This is why, this reference does not inherently disclose this portion. Or, you didn't consider this foreign language reference, but we submitted the international search report for the corresponding PCT application, and that stands as the concise statement of relevancy for this foreign language reference. Point to the specific facts that are that create the reason for quoting the MPEP.
OK。はい、ここまで、応答書における MPEP の引用は最小限にとどめるべきということを解説いただきました。では次に、判例を引用する場合の注意点について解説いただきます。So, Brian さん、quotations should be minimized when citing from the MPEP, but we sometimes cite legal cases not included in the MPEP. How can we improve our practice in that area?
Yeah, so, you raise an excellent point. For the MPEP, the examiners are familiar with it. But for legal citations, it's completely different. And so one of the things that bothers or can bother examiners is that when practitioners state the law but do not apply it. So, for example, they will say what is required to find claims anticipated. For example, under the Vertigal Brothers case, or obvious under KSR, but don't actually state the missing element. They don't say what element of the claims is believed to be missing from the applied references. And, this is relevant to any topic. It can apply to official notice, for example, under the Zerko case. And, it comes down to, you can't just quote case law to an examiner, you actually have to apply it. Again, point to the facts and explain why this case is relevant to the facts and therefore this case. So, so the suggestion, of course, would be to apply the law to the facts. Your examiners are not intended to be legal experts. Certainly some examiners have been to law school, some examiners have practiced in private practice before. There are probably examiners that were patent judges and decided to come back down from the board. But by and large, examiners do not have legal training. They have a few weeks in the academy, and they're not supposed to be legal experts. I mean, the USPTO does not hold them out as legal experts. They're supposed to be subject matter experts. And, when it comes to citing case law, then your examiners are unlikely to check your case citation. They know that, in fact, some of them have told me that they've been told not to get involved in case law discussions. So they're not going to look up what KSR says. They're not going to look up what In re Zerko says. And so therefore your citation must be self-contained. What that means is that, you can quote more than 2 or 3 sentences. If you need to, you can quote. And really what the focus should be is on your need. Still, you should not quote more than is necessary. But that necessary portion might now be a short paragraph. It might be, 2 sentences from one paragraph and 2 sentences from the next paragraph in this legal case. Your examiner might not know how to look up, F third. I mean, chances are they will Google it, but even if they do Google it, they're not necessarily going to, understand what they're looking at. And so after you quote this case law to them, and again, your citation can be larger than you would do for the MPEP, you still must explicitly state what you are trying to communicate. So again, in the case of KSR or Vertical Brothers, call out specifically what your missing element is, or I'm sorry, what the examiner's missing element is. If there's got to be a feature that's missing from the reference under Richardson v. Suzuki, show them what is the missing element. If we're talking about inherency, explain why that feature is not inherent to the reference that the examiner is relying on. And so again, we're just trying to make sure that our citations are self-contained, and more importantly, we're trying to apply it to the facts of our particular case.
Okay, thank you, Brian-san. So our approach to citing case law should be different from our approach to citing the MPEP, but both approaches require modern citations. We should also be clear about how the citation applies to the present application.
That's exactly right.
Thank you. はい、ブライアンさんありがとうございました。解説にあったように、応答書における MPEP と判例の引用方法は異なるということ。その一方で、両方とも本願に即した適切なものを引用すべきということでした。はい、今回はこれで以上です。ご質問や扱ってほしいトピックなどがありましたら、YouTube のコメント欄に書いていただくか、スライド最後に記載のメールアドレスまでお気軽にご連絡ください。日本語でも英語でも構いません。では本日もありがとうございました。失礼します。
Before everyone goes, I just want to announce next week, I think we will be including a former U.S. patent examiner in the stream. So please tune in for session 5 in, I guess it's 2 weeks, January 26th. ありがとうございました。
Can I say that in Japanese?
Oh, yeah, please.
Yeah. 次回セッション5で、現役の USPTO の審査官に、ゲストとして、登場していただきますので、ぜひお楽しみにしていただきたいと思います。はい、ありがとうございます。